Good afternoon. Thank you for tuning in. My name is Chris Jorgensen. I am the Director of Institutional Partnerships with BarBri. And you probably know that you're on a webinar that's hosted by My Law Learning in conjunction with BarBri. And we're here today to talk about career opportunities beyond qualification, focusing specifically on the United States and the UK legal markets. As I mentioned, my name is Chris Jorgensen. Just by way of background, I am a US qualified attorney. I am also a qualified solicitor in England and Wales. My practice was focused on civil litigation and criminal litigation back in the United States. I practiced about 10 years in a boutique firm and then moved into legal education with BarBri. I'm based in London, England, and I've been here for about 5 years. We, as a company, BarBri, just quickly, it's a US-based company that is an education provider. And we focus specifically on preparing lawyers and law students to pass qualifying exams, to become either an attorney at law or a solicitor. And we focus on jurisdictions in the United States and the UK, which is why My Law had asked us to come and speak with you today about that route and what is available beyond that route. So that's what I'd like to do. We've been doing this for about 50 years in the United States and internationally outside of the US, past 6 years. And our alumni totals about 1.2 million over those 50 years. So it's something that we do have a lot of experience with. So what I'd like to do to get started is to share my screen. I've put together a PowerPoint deck to talk through some of the highlights that I want to talk about. We'll have you here probably 30, 35 minutes today. I do want to give us an opportunity to answer questions on the back end of the presentation. There will be a chat function available for you to type in questions should you have any, and then we'll save some time at the end to address those once we've gone through the deck itself. So bear with me a moment. Right, okay, so as I mentioned at the beginning, we are talking about career opportunities in the US and in the UK legal markets. Now, that does require us to back up a little bit. When we want to probably start the conversation around the concept of dual qualification. So let me get these all up on the board. Most of you that are tuning in, as I understand it, are already qualified in India, and you have a background already in the practice. So when I'm talking with professionals around the world, regardless of what jurisdiction I'm speaking to, we tend to start the conversation around why seek a second qualification. Now, aside from potentially relocating to another jurisdiction, there's additional benefits that a practitioner can gain by having a second qualification. I'm sure all of you have thought of many of these already, but the ones that we tend to see at BarBri are these. You develop a global skill set by learning the qualification, by gaining the qualification of a second jurisdiction. This makes us better lawyers, and it gives us the opportunity to offer better client service at our firm or in our company. Now, it's of course not relevant for every practice of law, but many of us tuning into this kind of presentation are looking to develop or further an international career in law. And for those of us that are doing that, having that global skill set makes us better lawyers. It also widens our career opportunities. Whether we're looking to relocate to a separate jurisdiction or just cast a wider net within our localized jurisdiction, it gives us a competitive advantage over our peers. And I think we all know the net that is cast by US and English law and jurisdictional law in the areas of business. International cross-border transactions are heavily predicated or governed by English or New York law. We see this across the board, but even in Asian transactions, where a whopping 48% of those transactions tend to be governed by UK law. We also understand that many of the legal jurisdictions in the world are based on US or English and Welsh systems. And so having an understanding in an additional common law basis gives us relevance in some of those other jurisdictions. Not to mention the fact that many of the world's business or economies are based on US and England and Welsh legal systems. This kind of points to the relevance of having some understanding, or better yet, a qualification in those jurisdictions. So I want to talk a little bit about the US legal system. And of course, the place we want to end up is discussing what potential career opportunities are there. But in order to do that, I think it's important to back up a little bit. In the US, we have really a dual court system. There's the state system, and then there's also the federal system. Now, on the state side of things, we're really dealing with the day-to-day business of practicing law. And this is both in civil and criminal context. There are 50 separate US states in the United States, and each one of those is a separate jurisdiction. So we would be trying to qualify into one of those states to give us the opportunity to practice in the state courts of that state. And again, this is where most of the practice of law happens. Whether you're in New York or California or Illinois, as a lawyer, you most often are working in the state courts. So you'd be seeking qualification in one of those state bar associations. Now, on the federal side of things, this tends to be a bit more of a limited jurisdiction. And in the US, federal courts have limited jurisdiction based upon what's conferred to them by Congress or by certain articles located in the Constitution, which is an all-encompassing or an all-governing document that is kind of an umbrella authority for the practice of law and life in the United States. But suffice it to say that you'd be practicing in the federal courts on limited issues of law that come out of federal statutory law or by some other areas that arise. And the way that you become qualified in a federal jurisdiction is first by getting a state qualification. If you're qualified in a state, then you're able to move by motion into the federal district that governs that state. So what I mean by that is the United States on the federal level is broken up into different circuits. There's 11 of them in total, and you can see these broken up by color code. And depending on which state you are qualified in, you then have access to the federal district that overlays that state and other states. But most of us that are going to be practicing in the US will be focusing our practice in the state level. But I do want you to understand that there's concurrent jurisdictions. There's a state level of law, and there's a federal level of law. And some things like bankruptcy law or IP law are specific to federal court, but transactional law, certainly tort law, most things criminal are going to be found on the state level. So let's move on to talk about eligibility. I mentioned earlier that in order to be able to practice law in the US, you need to have a membership in one of the state bar associations. Each state in the United States is its own legal jurisdiction. And most of those states require that you have studied law in the United States, that you've gone to the US and you've done a 3-year postgraduate law degree, resulting in a Juris Doctor degree, and that it's an accredited law school that you attend. Now, there's a couple of states that have a wider opportunity that allow people that didn't take that route to pursue qualification. And those are New York and California. And they take a very different approach into what is a basis for eligibility. In New York, you need to have a 3 or 4 year common law degree. Now, the exception to this is that it can't be from Pakistan, India, or Bangladesh, unfortunately. The New York Board of Law Examiners has deemed that in order to be eligible from that jurisdiction, you need to also complete a US LLM. But if you've studied outside of the subcontinent and completed a common law degree that's 3 or 4 years in length, then you would be eligible to sit for the New York bar exam. Now for California, they take a very different approach, and they're concerned about whether or not you're qualified in your home jurisdiction. So for everyone that's a qualified lawyer in India that's in on the call, on that basis, you would be eligible to sit for the California bar exam. And when I talk about a bar exam, I'm talking about a centralized 2-day exam that once you pass it, you're deemed you've passed the requirements to gain membership and be an attorney at law in the United States. And so what that looks like, whether you're in New York or California, is a 2-day exam. You'll have 1 day, which is based upon a written exam. You'll be performing it's called a performance test, where you're given a client file, a mock client file, and it's meant to simulate that you're in a law firm and that you have a client that has some sort of a case pending in your firm. The file itself will contain facts based in perhaps client interviews or correspondence with you and your client, or you and opposing counsel, maybe deposition transcripts. And then in addition to the fact side of the file, there will also be case law, statutory law, secondary persuasive law that you're meant to pull rules of law from. So the idea is that the file itself will contain a memorandum from a boss, from a managing partner in the firm, perhaps, whoever is your immediate supervisor, and they'll be giving you a written assignment. That written assignment will require you to pull the relevant rules of law out of the case law and the statutory law, and to pair that with the relevant dispositive facts that you find from the client file side of things, pair them together in some sort of attorney written work product. And that's the performance test. In New York, you'd be doing 2 of those on your first day, and in California, you'd be doing 1 of those on your first day. Now, in addition to those, you would be writing short answer essay answers in total from a pool of either 14 or 16 different areas of law, depending on whether you're in New York or California. So that's day 1. On day 2, for both New York and California, you have the same day. You're answering 200 multiple choice questions on 8 core subjects of law. And the 8 core subjects would be things like real property, constitutional law, contracts, civil litigation, criminal litigation and procedure, evidence, and yeah, I think I said civil procedure. But those would be the core subjects. It would be 200 multiple choice questions broken up, 100 in the morning and 100 in the afternoon. You would end up having about just under 2 minutes to answer each question. Once you complete both of those days, that's the bar exam proper. You would also then have to take an ethics exam, which is a multiple choice question of 60 questions each. And the ethics exam is covering things like to maintain candor to the tribunal, to make sure that you're representing yourself in an honest fashion to your clients, to the opposing counsel, to the judge, to not commingle funds, clients' funds with your personal funds, to maintain client confidences, things like this. But when we talk about the bar exam proper, It's those 2 days that I described earlier. You have the ethics exam, which is a second separate exam. And if you're taking New York, you would also have to complete an online New York law course, which can be done from your own home. It's after taking a 19-hour New York law course, and then you do an exam, which is open book, multiple choice exam. So these are the things that you have to pass in order to be a qualified lawyer in the United States, either New York or California. And again, I'm limiting the discussion to these two jurisdictions because these are the jurisdictions that somebody in some fashion is eligible to qualify into, having not completed a Juris Doctor degree from an accredited law school in the United States. I anticipate that most of us on this call have not done a Juris Doctor degree. Now, the way to cure any deficiency would be to do an LLM in the United States, and that would give you a basis for eligibility for either New York or California as well. I suspect we'll have some questions for that on the back end, so I'm going to move on through the presentation. I want to talk about the US legal market a little bit. Now, we've been limiting things to New York and California. I'm going to be talking in broad brushstrokes in terms of the US legal market, because in every state in the United States, there will be some degree of these areas of business or practice of law. But these are the areas that we tend to see most prominent in places like California or New York. We all know that California is a tech in a fintech area of business. We have Silicon Valley, we have lots of upstarts, much like what you would be experiencing in India as well. And so the practice of law tends to shape itself around what kind of business we see. But it's not to say that you have to limit yourself to IP work or fintech or technology-based practices if you were to qualify and relocate to California. And again, it's not to say that you would have to be pursuing finance or capital markets or big corporate law for you to relocate to New York. But this tends to be what happens for foreign nationals when they move into these legal markets. Now, on the basis of moving into these legal markets, having a qualification to practice law in and of itself is not sufficient to have a basis to work in the United States. I think we all know this as a general concept, but you would need to find some sort of basis for sponsorship, for securing a visa in order to actually move into physical presence in the US, working in either New York or California. Other options would be to work for US law firms outside of the US, but sometimes law firms will sponsor foreign nationals to move into their law firms, either on secondment or otherwise. Of course, the COVID pandemic has really truncated what kind of visa opportunities are available at the minute. Currently, the US State Department has limited and stopped visa processing on the H-1B front. They've very much limited B-1 visas, as well as things like student visas or investment visas. So it's not a great time to be seeking relocation. And I think we all know this. There's also limitations on what parts of the world can physically move into the US. We'll see this again in the UK down the road. So I'm happy to answer questions specific to this later on, but we tend to see in places like New York and Manhattan, big US law firms handling corporate law or capital markets. There's also boutique firms that are working in things like immigration law, and then a number of smaller, what we would call high street firms in the US, or small law firms that do the day-to-day state law kind of stuff that I was talking about earlier. In California, there's big firms that are servicing Silicon Valley, handling the fintech, the upstarts, and the business practice in California. There's boutique firms that focus in those areas as well as immigration and whatnot. But I'm afraid that the takeaway on the US legal market at the minute is that the real bottleneck is securing a visa to actually move over. So I would advise you to be thinking in terms also of how would a US qualification benefit my practice outside of the US, because it's going to be a much more easier path, at least over the next 12 to 18 months, while everything COVID related kind of shakes itself out. So again, we're talking about very high level stuff here, and I'm happy to answer more specific questions, any kind of case study stuff that I can bring up when we have questions on the back end from my experience personally and my experience with the various attorneys around the world that I work with on a day-to-day basis in my role at BarBri. But I'm going to move on now, because I'm mindful of time, to start talking a little bit about England and Wales. Now, practice of law in England and Wales is relatively open. There's no restriction that's imposed in terms of admission based on nationality or residence. There is a route into practice presently called the Qualified Lawyer Transfer Scheme, the QLTS. It's a two-part assessment that foreign lawyers can take, and once they pass those two stages, they can then apply to be on the roll of solicitors in England and Wales. This is the route that I pursued and achieved to become a solicitor in England and Wales. And all of you from India, Pakistan, Bangladesh have this route available to you for the next year. The bad news is that it is going away in just over a year's time, and it will be replaced by what's called the Solicitor's Qualifying Exam, the SQE. Excuse me. And so I'm going to focus more on our discussion today about the SQE, because it will still be the way that foreign lawyers would pursue qualification into England and Wales once the QLTS no longer is in offering. And the way that you qualify via the SQE is by taking the SQE 1 and 2 and passing both of those, and then having 2 years of work experience. And there's some relaxed rules on what kind of work experience you need, rather than the traditional route into qualification in the UK. But it can be working in-house or in a firm in places like India, or doing some sort of paralegal work as well. And then, of course, you also have to pass a character and fitness inquiry on the back end to be deemed fit for purpose as a solicitor in England and Wales. So the SQE is a two-stage process. You pass SQE 1, which is a multiple choice test. It's computer-based, and it amounts to 360 questions delivered over 2 days. And this is the doctrinal law that you would need to know. This is the rules of law that govern contracts or tort or evidence or judicial review, solicitors' accounts, this kinds of thing. It's a multiple choice based test where you're given a small fact pattern, much like on the US bar exam. You'll have 5 potential answer choices, and you'll need to pick the correct one. The pass rate you need to get is generally around 58, maybe 60%. And if you score higher than that, then you've deemed to have passed the SQE. It's offered twice a year, November and May of each year. And then once you've passed that, you move on to SQE 2. And incidentally, this is the same structure of what the QLTS looks like as well. So if for some reason you were going to pursue the QLTS before it goes away within this year's time, know that you would be doing a series of assessments that looks very much in kind to what I'm describing now via SQE and SQE2. But SQE2 is your skills-based assessment. This is where they're testing you on your professional merit, and you'll be going through mock scenarios where you're being tested on advocacy, case analysis, legal drafting and writing, legal research, client interviewing, this kind of thing. And it would be broken up into 3 different areas of law. So they'd be testing you not only on the skills-based competency, but also on your understanding of procedural law in the areas of business law. So I'm talking about things like entity formation, drafting company minutes, maybe drafting and issuing stock certificates. They would be testing you in the area of civil and criminal litigation, perhaps your ability to advocate for a bail hearing or advising your client on issuing stocks again or something like this, or civil litigation, criminal litigation. And then also the third area of law is property and business law. So you might be having to advise someone on the sale of their property, or you might need to be drafting a will, or advising somebody how to negotiate probate for a family member that has just left them. And again, it is highly skills-based. They're wanting to see that you can demonstrate how you would negotiate handling these kinds of professional competencies. But along the way, you need to be advising on comprehensive and correct procedural law along the way. Once you pass both of these, then you would submit to a character and fitness report and then be on the roll of solicitors. About 10% of all solicitors in England and Wales have come in through the QLTS and will be then, after 2021, everyone will be going in, whether you're a traditional LLB grad from the UK or you're an Indian lawyer looking to qualify as a solicitor in England, everybody would be taking the SQE to qualify. So the structure of the legal system in England and Wales is different from that of the US. In the US, where we had this concurrent dual jurisdiction of federal and state courts, we don't have that in the UK. We have a system of courts that is uniform throughout wherever you are in England and Wales. It is one legal jurisdiction, and it is broken up this way. You all know this, I'm sure, that the practice of law is divided amongst solicitors and barristers. And solicitors do about 90% of the work. This is what you would be looking to qualify into, likely, because that is where most of the work is done, and it's a much easier route into practice. We're looking at about 145,000 UK solicitors versus 16,000 barristers. The barristers do the advocating. They take a matter that has been worked up by a solicitor and they present it to the courts. Solicitors can have rights of audience. They can do an additional qualification to have rights into the higher to the higher courts. But even without that, they can work into the magistrate courts and the tribunals. Barristers would be handling matters beyond that, Crown Court and beyond, but solicitors can gain higher rights of audience to work through up into the high court. And the solicitor's role is more of a client-facing. You would be taking instructions from clients to advise them on a certain matter, to prepare documents for them. You might be representing individuals or a business entity, and you'd be negotiating on their behalf in business transactions. You would also be working through a lawsuit up into a certain point, where there would be then bringing into barristers into the matter to actually litigate the matter in court. But I know that the close historical and cultural relations between England and Wales and India and Pakistan that I'm likely telling you things that you already know. So I'm going to move on. When we talk about the English legal market, there are international firms based primarily in London, Birmingham, and Manchester. We know that London, or the city, is one of the global hubs for international finance, for arbitration, and that there are big US and UK law firms that are based in London. We've seen a big move from the US of the big law firms basing themselves in London over the past 10 years, establishing a presence in EMEA and in APAC from their London offices. We haven't seen as much of the UK firms moving over into the US. But all of the firms based in London tend to have an India desk where they're servicing Indian businesses and clientele, whether those Indian businesses have a presence in the UK or otherwise. And again, those are going to be coming out of London, Birmingham, and Manchester. There will also be boutique firms in all of the areas of business, whether it's fintech, finance, capital markets, shipping, arbitration. When it comes to arbitration, we do tend to see the bigger firms kind of handling most of the arbitration, but you can find boutique firms that handle that as well as immigration and whatnot. There's opportunities to work in-house as well. Of course, the financial institutions, we all know this. We and BarBri personally, I know cases of people that were Indian lawyers that moved over to the UK, that pursued qualification via the QLTS, which would now be the SQE for all intent and purposes. Once they secured that UK qualification, they were then dual qualified. I know other Indian lawyers that we've helped to qualify in New York and California, and once they have that dual qualification, they've secured in-house positions with clients like Goldman Sachs, Credit Suisse, other hedge funds, other financial institutions, and they're based now here working as a dual qualified lawyer, primarily as a solicitor. I know others I can think of that have pursued New York qualification with BarBri. They just happen to be based in New York, but they're working with some other firms, New York-based firms handling various areas of the practice. I can think of some clients who are on financials desks, arbitration as well. So it's available. It might be a little harder to do from India, but I think between the US and the UK, there's an easier path to practice for the English legal market. And that's in large part because of the historical ties that the two countries hold, that there's a bit more work between the Indian subcontinent and the UK than the US and the Indian subcontinent. And there's just more familiarity. So I think between the two, I would be encouraging you to look at the English market rather than the US market, but I don't want to dissuade you if your heart's set on looking into how do I qualify in the US and would there be opportunity for me there. Beyond Brexit, real quickly, we don't know exactly what's going to happen in terms of the English legal systems or the legal market's relevance in mainland Europe, but we certainly do think that there will, depending on what happens with Brexit, the UK as a country is going to be looking to establish different trade deals, and certainly India is in the mix on that. So there could be an opportunity, as I'm thinking through this, for Indian dual qualified lawyers as solicitors and Indian lawyers to drum up business or to service business as those trade deals between the UK and India develop. So I think these are things to think about that I'm sure that many of you have already thought about. It's high level stuff that we're talking about today, but I'm curious to see where the questions are going to go from here. So I'm going to stop sharing my screen at this point, and I'm going to bring Nikhil into the mix here and see if there's any questions that we need to address. I'm going to pull up my chat function here. And I'm told that I've been muffled this whole time. I'm sorry to hear that. I have a question here. Let me just clarify on the voiceover. Can anyone hear me at this point? All right, I'm getting from panelists that you can hear me. That's great. There's questions here about, we want to hear about the New York bar exam. Okay, so the New York bar exam, it's a 2-day exam. One day is a written exam. The next day is where you're doing multiple choice questions. It's graded on a curve. It is 100% a competition amongst everyone else that you're taking the exam with. You're tested really on 14 different areas of law. And the core areas of law that you're tested on both days will be things like contracts, real property, civil procedure, criminal law, evidence, torts, and what am I forgetting? And constitutional law. In addition to those core subjects, you'll be tested on things like secured transactions, on agency and partnership, on family law, on business entities, business formations, and you'll be tested in the rules of law. You'll not need to know any case law, but you'll be tested on your understanding of rules of law as it applies to fact patterns. So on both days, you'll be presented with fact patterns in different fashion, whether it's a multiple choice question, whether it's an essay question, and whether it's a performance test. You'll be needing to identify relevant facts in a fact pattern that leads you to identifying the appropriate rule of law. It's an intense 2 days. It's a marathon. You don't need to have a perfect understanding of any area of law, really just enough to pass. And that's what you would be looking to learn, is a sufficient level of understanding in all the areas of law to pass on a curve. Every exam is written a little bit differently, so the curve fluctuates, but you need to think in terms of probably scoring around 70% in order to pass. And the makeup of the scoring, your essay exam is about 30% of your grade. Your second day, your multiple choice exam is 50% of your grade, and your performance test is about 20% of your grade. Starting pay would look like in the UK and the US after clearing the requirements. It depends upon the law firm that you get with and the kind of work that you're doing. Now, the big law firms, the Magic Circle firms in the UK, the big US law firms, pay very well for starting salaries. In the city, it can be up around £110,000 to start. and even higher. They keep playing off of each other, the big firms. The US firms, when they came in, they shot the salaries up very high because attorneys in the US tend to get paid very well. They also get worked to the bone. The work-life balance it's not great. You are expected to bill considerable amount of time, 1,800, 2,000, 2,200 hours billable a year, maybe even higher, depending. You're expected to work weekends, nights. You're expected to be kind of on call. And there's a little better work-life balance in the UK firms, as I understand it. I haven't worked for any, but this is what's been told to me anecdotally through my discussions with solicitors. And so I digressed a little bit. The UK firms have been bumping up their salaries in the magic circle and the silver circle to keep pace with the US firms. Now, if you're not in the big law firms, either in New York or the city, London, your salary is going to reflect that, and it's going to be considerably lower. Salaries in the US always tend to be higher than what solicitors get paid in the UK. And big law firms tend to pay better than regional or boutique firms. You would be looking if you're working in a boutique firm outside of the city, so like a high street firm in the UK, I think you would probably be looking to come in somewhere around 35,000 pounds a year. And in the US, you would probably start somewhere, depending on where you are in the US. The cities always have a higher cost of living, they get paid better. But let's take a city that is not New York or LA, maybe around $65,000 a year. And that's a starting salary. There tends to be bonus packages depending on if you hit your billables. And when I talk about billables, I'm talking about you are timed, you bill your client on a segment of time each hour. And it tends to be, both in the US and in the UK, a 6-minute increment. So every 6 minutes, you're billing your client for work that's performed. And you're keeping track of your day on a 6-minute increment, and you have billable targets that are set for you. Now, your goal is to surpass those billable targets. Each firm is different. Each area of practice of law is different. Litigation may be easier to hit your billables than transactional or vice versa. But your productivity is measured on your ability to hit your billables. And not every task is billable. You don't bill them, you don't bill your client for everything that you're doing. And this is where the challenge comes, because a lot of your day can get eaten up in tasks that do not warrant billing your client. And then you still have the pressure of billing your client to hit those hours along the way. I suspect this is similar to how the practice is treated in India. But this is what you would be looking at in any big law firm. Now, in-house work, when I talk about in-house, I'm talking about working for a company. And this is whether you're in the UK or the US. In-house lawyers tend to have a little better work-life balance. They can work a little more, we call it 9-to-5 work, where they can switch off at the end of the day. That's not always the case. And it tends to be that as you move up in an organization, your responsibility increases as well. And so you may not be able to maintain that 9-to-5 work life, but The good news is that as you move up in responsibility, your remuneration tends to increase as well. Maybe you become a partner. Maybe you're then on getting profit share from the firm or from the company. And as you grow as a lawyer, your value to the company or to the firm grows, your responsibility grows, and then you are able to charge more, and then of course you reap more benefit from the profit that the company or the law firm earns, I guess. I've got a few more questions here. We talked about starting pay. Are all solicitors that are employed by the government in the UK? Solicitors are generally not employed by the government. Most of the solicitors are working in the private sector. You could work in you could work for the Crown Court, for the Crown Prosecution Services, which is a prosecutor. That would be government work. You may work in some of the government agencies as a solicitor, but most of the time you're working for companies or law firms in the private sector. I have another question here. How different is the QLTS from the SQE? The QLTS and the SQE are quite similar. The SQE is a more robust assessment. So you saw the slide for SQE1, where it's 360 multiple choice questions. On the QLTS, what's called the MCT, which is the first assessment, you're only answering 180 questions. So it's half as many questions. SQE2 and the second phase of QLTS are very, very similar as we understand it. SQE2 is still in its formation, but they'll be very similar. The one difference is that via the QLTS, there is no work requirement. You don't have to demonstrate any work experience. For the SQE, it's likely that you will have to demonstrate some kind of work experience, albeit it'll likely be available that you've done it in India or your home jurisdiction. Tell me more about international taxation laws and law firms and the scope of Indian lawyers. I'm afraid that's not my area of expertise, and I can't give you specific information about tax law and as it applies to international law. The big law firms will have a tax practice, and in as much as those firms service Indian companies, there will be a need for Indian tax law expertise. So you would need to identify the firms that have a book of work in that area and demonstrate some sort of expertise in those tax laws to get a foot in the door. But I'm sorry, I don't know actual names of firms to be pursuing. I have a question for any book recommendations in the long run for professional competency during the screening process. The books that would be helpful, depending on where you're going, if you're looking for US qualification, Prosser on Torts would be very helpful. Another book would be Evidentiary Foundations. And I'm trying to remember the name of the author for that. I think it's Chomsky, but I don't recall exactly. Those would be helpful. I would highly recommend that you could look at the OUP books, the Oxford University books, Oxford University Press books for the UK, for the procedural law, and working to practice your competency in the areas of researching on search engines like Westlaw and LexisNexis would be important, and just practicing legal drafting, legal research, advocacy. Specific books beyond that, I would be looking for books that are addressing skills rather than the doctrinal law. Another question. opportunities in corporate law as well as commercial arbitration and taxation in the US and the UK. Again, your arbitration focus in New York and London for those jurisdictions. You would be trying to target the big law firms because they tend to be the ones doing most of the arbitration and the tax. So magic circle firms in the UK and the big law firms in the US. You wouldn't want to be pursuing the boutique firms, and so I would just do Google searches. I'm not going to name drop specific names of firms for you to look to, but you would be looking in those areas. Talk about being an Indian law graduate. Should I go about securing a training contract? How can I stand out beyond LLB students? Okay, that's a good question. I'm planning for the GDL this year. Can you also suggest a good university? The universities, the Russell Group universities are very good. I would be looking at Leicester, or Durham, or certainly Oxford or Cambridge if you have the grades for it. UCL, University College London would be good, King's College. You could just Google for Russell Group and look at those universities to pursue. In ways of standing out for a training contract, you need to demonstrate an expertise in something. It doesn't have to be an expertise that you're going to practice, but you need to demonstrate to the firms that you have become a student with a passion in some area of law. And whether it's maybe tech law, how AI is playing out in contracts, or the role of technology now in discovery, something that gives you a calling card to stand out from everybody else that's looking to secure a training contract. I would also focus on soft skills. Everybody that's going for a training contract will have good marks from their schools. You'll need to be exceptional in the ability to advocate, or to, whether it's legal drafting or legal researching. Keep in mind that the practice of law, at the end of the day, we're working with people. And that as much as it's about billable hours or drafting in front of your computer, or however much technology comes into play, at the end of the day, you're servicing a human being. So your ability to leave an impression with your clients, with the judge, with opposing counsel is paramount. Your ability to work in an organization, to digest information quickly and reproduce it in a simple fashion. Your ability to learn and handle complex tasks quickly and easily. These kinds of soft skills will stand out in an interview, but then more importantly, they're going to stand out in the practice itself. So I think those are the things that hiring committees look to find when they're handing out training contracts and hiring along the way. The SQE has a requirement for practical training in the UK, something the QLTS doesn't have. To avoid this one, would one have to decide on the QLTS soon, as it is being phased out? That is correct. The QLTS is going away, and it is a route into practice that does not require that you have work experience. So you need to get through the first phase. You need to get through both assessments by the end of next year. And so that really means making a decision very quickly to get through the MCT as soon as. We have programs that can prepare you for the next sitting of the MCT, which is in January, and then you would need to pass the MCT in January, and then start studying for the second phase, which is called the Objective Structured Clinical Examination, either in May or November of 2021. And then you would pass those in 2021 to avoid having to demonstrate some work experience. Now, you can get the work experience in India. It doesn't have to be done in the UK, but it will be a requirement under the SQE, as we understand it, to be eligible to be a solicitor. Question here is, what would be one advice for your younger self who's looking forward to the legal profession? That's a really good question. So what would I advise of my younger self as I was stepping into the legal profession? I think for me, I was very, very interested in trial practice. And so when I got out of law school and passed the bar, I immediately became a prosecutor and started trying cases. And then I moved into a civil firm in civil litigation. And I would have spent more time in law school as well as in practice learning about transactional law. I would have made myself maybe a little less of a litigator and a more of a transactional lawyer, because I think that there's more relevance there. And that I think as a young lawyer, we, in some respects, to get our foot in the door, we have to take what's available. And that may not be the area of practice that you're dying to do. But it might be that once you get into a firm, you can start to move yourself in your career to the areas of law that you want to practice. So I would work to become as relevant and as accessible as possible as a young lawyer, with the idea that later on I can move into a different area. But the thing that you need to remember is that once you get your foot in the door there, you need to have a game plan. You need to identify where you want to go. So take some time and really think through, what do I want my practice and my career to look like? It's a tough question, because we will learn along the way that the practice of law is ever changing. It may not be exactly in 5 years' time what it is now. And it's hard to then forecast into the future what you want from your law career. But you need to have some sort of sense where you want to go, make a decision and stick to that as best you can, and work to direct your career that way. Once you get your foot into the door, continue servicing the area of work that you are being paid to do, but begin to position yourself with the people that are doing the work that you want to do. Find a way to get yourself in that area of the firm or in that area of the profession, so that you can you can somehow get into that area that really, really holds your passion. The practice of law, and I can comfortably say this, no matter what jurisdiction you're working in, is a demanding mistress. It is going to require and expect a lot from you. And so you owe it to yourself to put yourself in an area that you can really enjoy, so that you can give it that commitment that is required of it. Because there's a lot of lawyers in the world, but to be truly exceptional, to get what you want out of this practice, you need to commit to it and be an exceptional lawyer. And I think to be exceptional, you need to have a passion for it. And I think to have a passion for it, you need to be doing the part of it that you love. So that's what I had to say on what I would tell my younger self. I hope we answered some of your questions. I hope I inspired you to take a step towards qualification in either the US or the UK. If you have additional questions, Nikhil can put me in touch with you, or put BarBri in touch with you. I thank you for your time, and I wish you all the best in your careers. wherever they may take you. I'm going to sign off now. Thank you.